I just want to go over and point out a couple of things of importance before we go forward, because we're out of the clinical area here now. We're in the legal area, talking about the law, but really we're reviewing a Supreme Court decision, Jaffee versus Redmond. So when I'm doing this on site or in the classroom, I ask the students or learners, who can name me a Supreme Court decision? And they'll come up with Roe versus Wade, Brown versus the Board of Education, or just it's been on TV now, Loving versus the Commonwealth of Virginia, a couple others, but really not very much, because there's really hundreds and hundreds of Supreme Court decisions. So this Supreme Court decision we're going to be talking about here now is Jaffee versus Redmond. So has anybody heard of that? So I just want to make sure that we cover a couple of points about this before we move forward. It's very important, and it pertains to us. If you printed out your paper here, you should be able to have your paper, and I wanted you to review that before we do move forward, so we can tell you the results of Jaffee versus Redmond, because it's a Supreme Court decision that absolutely affects us as counselors. Okay, so in the just looking at my notes, in the decision they refer to psychotherapists, which is a general term. We know there's no such term as a psychotherapist. You're either a counselor, a CASAC, a psychologist, a psychiatrist, but psychotherapist is not really a job title, a license. They don't license psychotherapists. But for our intents and purposes, we're considered psychotherapists here. You know, we fall under the category of psychotherapists, and that includes psychologists, counselors, social workers, everybody. So they call psychotherapists, it pertains to us. So if you're a counselor, if you're CASAC, licensed social worker, you're a psychotherapist. Congratulations, you got a promotion. Okay, so in the case where the police officer had shot and killed a suspect who was threatening to kill somebody else, she had a difficult time with that, and she was going for counseling for trauma. And yes, we're supposed to address trauma and counseling, so she went for counseling, and it was a good thing that she did to feel she had for post-traumatic stress, but for shock, she had killed someone. So in the court decision, the family of the person who was killed filed a wrongful death suit, and the psychotherapist, her counselor, was called into the court, and they wanted her to divulge her information in court, and the counselor, the social worker, the psychotherapist declined, refused. Okay? So under the basis that is privileged information. So privilege or privileged information is not a clinical term for it doesn't, for us, as far as confidentiality or HIPAA confidentiality laws or the privacy rule, which are clinical mental health, healthcare laws federal laws that we use. Privilege is a legal term. Privilege is a legal term that pertains to divulging information in court. And if that information is privileged information, you are not required you can refuse to divulge that information in court, especially in open court, because you don't know who's sitting there in the gallery. Those are news people and news reporters, and they're taking notes, and it happens all the time. Information that's talked about in the court, or somebody that says something in court, in open court, is written down and reported in the news 10 or 15 minutes later. So privileged information is we do not have to divulge information in court as psychotherapists, based on Jaffee versus Redmond Supreme Court. So read through that. Now the lower court awarded the plaintiffs in the case, which was the family, damages because the the psychotherapist who had refused to testify in the case, the judge said that you can imply that that's a negative connotation, and you can hold it against it, which was ridiculous. And so in the appeal, the American Psychological Association, the APA, got involved and filed a brief. Now, there's a word in there, and I only have to look this up because I'm not a legal person, okay? But here's the word. It's in. My girl says it to me here. Certiorari. Okay, certiorari is a writ or it's when a higher court is asked to review a lower court decision. So that's what he did. The APA appealed it and took it to a higher court, and the APA got behind the case to say that there's a privilege there with psychotherapy for several reasons, and that, you know, I'm going to give you the reasons in the next slide in the presentation to give you the result of this case. Now, if you're in New York State complies with Jaffee versus Redmond, and that psychotherapist information is privileged information. And if you're from an out-of-state counselor watching this, you can always check to see if your state complies with it. But it's a Supreme Court decision, and every state has a legal doctrine to be compliant with Jaffee versus Redmond for psychotherapists. Every program, every state upholds that, and we uphold that here in New York State. So I'm going to move forward and give you the law and the results of Supreme Court decision Jaffee versus Redmond. Just wanted to give you this background because this is a very, very important case that applies to us. And, you know, maybe you haven't heard about it, but you're going to hear about it in this training, okay? So let's see what the results from the Jaffee versus Redmond Supreme Court case 1996, Supreme Court State Case 1996. Let's see what the results of Jaffee versus Redmond and how it affects us, how it affects you as a CASAC, as a social worker, as a counselor, how it affects all of us. And you need to know this information. And I've included it in this training. Okay? All right. Here we go. So, as you know from the reading, the initial decision was to award the money to the plaintiffs, and then the Seventh Circuit Court reversed that decision in an appeal, and then both parties were appealing, and it ended up in the Supreme Court to make a decision, a final decision, Supreme Court decision, on psychotherapist-patient privilege. And these are the findings of that Supreme Court case. Federal Rule of Evidence 501 authorizes the federal courts to recognize a psychotherapist-patient privilege. So this is under the Rules of Evidence. Which is, we're going to get into, we're out of the clinical world again here, but this is Federal Rules of Evidence 501 authorizes the federal courts to recognize psychotherapist-patient privilege. Common law principles applied in the light of reason and experience strongly support recognition of a psychotherapist-patient privilege that psychotherapeutic clients have a strong expectation of confidentiality. I'm ad-libbing here. Yes, they do. Our clients, our patients, and in common law, they just have when people come for treatment, they have a strong expectation of confidentiality. And part of informed consent and patients' rights and responsibilities, we're informing them about the confidentiality of the therapeutic alliance. Confidentiality is essential to the success of psychotherapy. Okay, that's what this was the APA's argument in Jaffee versus Redmond, but yes, confidentiality is essential. It's an essential component of counseling and therapy, and it's essential to the success of psychotherapy. Society has a strong interest in fostering psychotherapeutic relationships and in protecting client privacy, right? So for society as a whole has a strong interest. They don't know it, we know it, but there's a strong interest in fostering psychotherapeutic relationships and for people to get in counseling. We know that 51% of any individuals during a year may seek out mental health or addiction counseling. And D, the benefits of the psychotherapist-patient privilege outweigh its costs. So that's cost to society. Okay, so any cost to society of not having psychotherapist privilege, patient privilege, outweighs its costs. New category 3. Applying the psychotherapist-patient privilege using a case-by-case balancing approach would substantially undermine the value of the privilege. So what they're saying here, as far as it outweighing the cost to society, it's just applied to every case. Okay, so they can't come back to the court for a case-by-case decision of psychotherapist-patient privilege. That would it would undermine the whole value and clog the courts. Okay, so it's for everybody. We're not going to do a case by case. Okay, so these were the results. The Supreme Court affirmed the 7th Circuit decision. Now the 7th Circuit decision overturned the initial decision by the lower court to award the plaintiffs, the family in the case, for a wrongful death and gave them all that money. I just want to look at my notes, $545,000. So they overturned that decision, and then it came to the Supreme Court, and the Supreme Court held or affirmed the 7th Circuit decision that psychotherapist-patient privilege did exist and overturned the lower court decision. So the court decision supported the arguments presented by the APA, and above are the arguments presented by the APA, and I and we should, but we agree with all of that. Okay, so that's the court case and the findings and the results. And you have the supporting documentation in the printout. And I think you're on pretty solid ground when it comes to not responding to a subpoena. So, what does that all mean to us as counselors, social workers, as psychotherapists? What does that mean for us? It means we do not have to respond to a subpoena. Okay? If you receive a subpoena, wherever it comes from, you do not have to respond. We do not have to respond to subpoenas. Let me give you an example. You may get a subpoena, could be from a court, could be from a court signed by a court clerk, could be from a prosecutor, it could be from a law firm that has subpoena power. You could get a subpoena to come to court and testify or give evidence, or a subpoena records of someone, or subpoena someone's chart, subpoena someone's psych eval, or your session notes. Okay, you do not have to give up that information. You do not even have to respond to a subpoena. You do not have to respond to subpoenas. That's what it means for us. Why? Okay, firstly, you receive a subpoena about one of your patients from wherever. We cannot even confirm or deny if that person is a patient of ours at our program based on HIPAA federal confidentiality laws and the privacy rule. We can't confirm if someone is in treatment with us, or if that person is in treatment with us. Let's look at my notes. Based on HIPAA and the federal confidentiality law. But we do not have to give up information or divulge information because it's privileged information under Jaffee versus Redmond. So those are the two things, okay? We do not have to respond to a subpoena because of HIPAA federal confidentiality laws and the privacy rule that it's, we can't even confirm that the person is a patient of ours. And we do not have to divulge the information because it's privileged under Supreme Court decision Jaffee versus Redmond. Okay? Everybody in agreement with me on that? Good. So, let me give you an example. I received a subpoena for a psychiatric evaluation of a patient of ours. I was in a decision-making position. I received a subpoena. It was from a law office, from a law firm, subpoenaed, wanted the psychiatric evaluation of a patient. And the law firm that gave us a subpoena was representing a family member of the patient who wanted to prove his inability to manage his money because he was managing a trust fund. And they wanted to manage the money. So the prosecuting attorney, or the attorney against our patient, sent us a subpoena. They wanted his psych eval and his psychiatric diagnosis. So I looked at the subpoena. I've seen it was a letter signed by, from the law firm, subpoena, and it said, failure to comply with this subpoena could result in 5 years imprisonment and a $50,000 fine. Okay? I threw it in the garbage. Sent me another letter, subpoena, threw it in the garbage. Third letter, I said, I got to do, I'll call the guy, like to enlighten him on what the situation is. So I called him, spoke with the attorney, and I said, hello, I'm Clint, the supervisor, blah, 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 program. I said, I'm doing you a favor. I'm receiving your letter here. I'm giving you a courtesy call, okay? We do not have to respond to your subpoena, okay? He said, but it's a subpoena, he said. We're subpoenaing you. I said, listen, I do not have to respond to subpoenas. Okay, let me tell you why. Based on HIPAA confidentiality laws, I cannot even confirm or deny that this person is a patient of ours. Based on the privacy rule, we can't give up information like that. And I'm not going to give you their psychiatric diagnosis because of the privacy rules and HIPAA confidentiality laws. So he said, but you have to, it's a subpoena. I said, no, I don't. Let me give you the Supreme Court case. Based on Supreme Court decision Jaffee versus Redmond, you can look it up. I know you got the books there. We don't have to divulge information on our patients based on Jaffee versus Redmond, Supreme Court case. Look it up. And he said, okay, and he'll get back to me. Of course, he never got back to me. And I wanted to know who to send the bill to. Like the lawyers always say, who do we bill for that hour? I wanted to bill him for a legal consultation. Okay, never heard from the guy again. Okay, so if a patient wanted me for their defense or some case that they were making a case, they could sign a release of information form, and I would even testify as a witness on their behalf, as an expert witness. Or with the psychiatrist would, but we're not going to respond to a subpoena. So, and that applies to all our field, okay? So, let's move on to the next lesson in the course where we talk about a court order. What do you do when you receive a court order? Interesting. Let's see, shall we?